The difficulty that I have with this judgment is, and I'm not sure, it's not part of the pack, unfortunately. I don't think it's part of the pack.
Of the bundle?
Yes. In paragraph 9 of that judgment, but do you remember that judgment?
It's
because I want to be fair on you, but the thing is, I'm asking this based on the criticism that you raised.
If it's a 27 judgment, it's
2017.
Yeah, 2017. It's some time ago. I've had a couple of insolvency matters which I heard. So no, I don't recall.
But can I just point out?
Yes, you can.
The issues with this judgment in response to your response in relation to the quality of your judgment.
Yes, please.
In paragraph 9 of that, in paragraph 9 of this judgment, what you first do, you speak about the acts of insolvency, and you list about 5 of them. And when you start speaking about acts of insolvency, you give an impression that you are dealing with compulsory sequestration. In other words, what you are dealing with here is compulsory sequestration. And once you have outlined these, in the following paragraphs, you don't even deal with any of these acts of insolvency and what or which one of them is actually applicable in this case. And there is no reasoning in relation to the requirements of compulsory sequestration and as to why the person who is being sequestrated in this particular matter meets those requirements. And that is the first flaw that I found in this judgment. But apart from that, you confuse issues. In paragraph 21 of that judgment, you say something that is quite surprising. You speak about somebody making a notice to surrender their estate. And if you start saying somebody surrendering their estate, you moved away completely from compulsory sequestration. Yeah. You are now dealing with voluntary surrender. And that is a second issue that I have with this judgment. That shows, one, confusion in relation to the area of law. But secondly, lack of attention in relation to the research that is needed to actually get into the reasoning and the order that you're going to give. But the third fundamental challenge with this judgment is the language that is used. In paragraph, you can just bear with me just for a second. In paragraph, I think 20 of the judgment, the language, the sentence construction that is used there, and when you read the entire judgment, and I mean it's unfair because you don't have that judgment, you can see. But I just want to say that this judgment and the judgment that I referred to, it has similar sort of things that come out of them, where you rely on the law, not the law in terms of cases, but the law in terms of the statute itself. But your interpretation of the statute and your reasoning in relation to the statute leaves much to be desired. So I'm not sure whether it's accurate to say that the quality of your work generally, it is satisfactory. I think there are points of weaknesses, and it's quite disappointing that some of the bodies have not highlighted it, and which raises a concern that perhaps maybe criticism seems to be restricted to certain people and not other people, and that for me is a concern. I'm not sure. What is your response to that?
Firstly, Commissioner...
No, DCJ.
Commissioner Malema?
I think in all fairness, that question is not in keeping with what we have adopted. Because it's not only the law bodies that have got a right to raise issues with the candidate before he sits here. We all do. If we look at the law bodies report and the issues we have, which the law bodies have not raised, we all have a right to raise those issues and send them to the candidate. And that hasn't been done. Yeah. And it's not me, it is through the admission of the commissioner that hasn't been done. And it's unfair to the candidate and to all of us, because even in the deliberations, that point cannot be referred to, since it has not been canvassed.
Thank you, Commissioner.